Welcome to the Law Society Gazette podcast, unpacking what matters most across the legal profession.
Hello, and welcome to the Law Society Gazette podcast. I'm Paul Rogerson, Editor-in-Chief of the Gazette. The minimum age of criminal responsibility in England and Wales is 10 years old, and has been so since 1963, when it was raised from 8. This is low by international standards. So is it time the bar was raised? And if so, why? To discuss this today, I'm delighted to be joined by two esteemed guests. Kirsty Brimelow KC of Doughty Street Chambers has practiced in international human rights law, criminal law and public law for over 30 years. She is the current chair of the Bar Council, which has made raising the minimum age a campaigning priority. Welcome, Kirsty.
Thank you very much.
Dr. Laura Janes is a consultant solicitor and honorary KC, specialising in prison law, criminal appeals, mental health, public law and community care. Her many roles include chairing the Association of Prison Lawyers and sitting on the Law Society's Criminal Justice Committee. Hello, Laura.
Hello.
So, Kirsty, if I can come to you first, why did you decide that the age of criminal responsibility would be a flagship campaigning priority this year?
Well, children in the justice system seem to me to be an obvious priority. My interest in how children are treated has been from my practice. I've been a consultant for UNICEF for many, many years, and UNICEF Nigeria and UNICEF Myanmar in particular. So I've seen close up how children are treated globally, and I've been leading trainings of how children should be treated in the justice system. So of course it caused me to focus on what happens at home. As a very junior barrister, I spent a lot of time in the youth court and saw the functioning or the dysfunctionality of that process. And at the heart of it were children who often I felt were not following what was happening. I could feel from my own representation of them that this was perhaps not the place where they ought to be in the criminal justice system. There was many other challenges in their lives which needed to be addressed, and the criminal justice system was just not equipped to tackle those. So when I became chair, I was delighted to make it a priority to look at the minimum age of criminal responsibility.
Thank you. Laura, is that your experience? Would you share those views?
I would absolutely echo those views. In my own practice, I work with children and young adults who are in detention, whether it's mental health detention or penal detention. I have done so now for about 20 years. And what Kirsty there describes is exactly my experience. Often the criminal justice response and the behaviour that the child has engaged with is just the tip of the iceberg of the problems in their lives. And usually the criminal justice system makes those worse, not better.
Okay, thank you. The Bar Council's report recommends 14 years old as the as the new limit that it would propose. Why is that the right threshold, do you think? Why not 12, for example, which is the age in Scotland, or 15? Why that particular age?
Well, first of all, 10 means that we are an outlier in Europe. Europe is generally about 14 years old. And so it makes legal sense that we are aligned with other liberal justice systems. Also, the UN has consistently recommended that the UK increases the minimum age of criminal responsibility to 14. So it's in line with that analysis examination by the UN committee looking at children in justice systems and treatment of children by states. So it fits with that. And also it fits with our knowledge, which has evolved, particularly relating to neuroscience. And we know much more about the development of the brain of a child and how children perceive risk in a different way. They are much more drawn to short-term gain. They don't weigh up what they're doing in the same way as an adult will. And that is not reflected in our criminal justice system when within it is a criminal intention or a criminal recklessness. But that is really should be applied to adults, and we're applying that same test to children without treating them in a different way. So it fitted both with the law as developed and also with the neuroscience as we know it. And the final point is we also have the data that prosecuting children sets them on a criminal pathway. So in terms of public protection grounds, we are actually more endangering the public by putting children through a criminal
It's
justice system.
counterproductive.
It's absolutely counterproductive.
Yeah, that's an interesting point because the numbers are not high, are they? Your report states, reports that only 1,590 children aged 10 to 14 were found guilty of offences in 24-25, and only 22 of those received sentences of immediate custody. So that undermines the argument that this needs to be retained for public protection, doesn't it?
Yes, I mean, the numbers of children actually who are sentenced to detention is small. The argument there as well, they're small, but it's significant. So is it still required? We would say that there are cases which are extreme cases, and we know about those because they tend to hit the headlines. But that is not a reason for looking at the generality of how we treat children and setting our law accordingly. And accordingly, if we have the result where detention is not felt to be required by that offending, then we really should be putting the child through a different system to the criminal justice system, where there might have been some restriction on their liberty, but under a civil proceedings, because that will mean that they are not then stigmatized as a criminal, and that therefore will potentially prevent them heading down that criminal pathway.
Yeah, Laura, is your experience bringing children into the criminal justice system being counterproductive?
Well, absolutely. You only need to look to the report by the chief social worker that was issued on the 7th of July this year, which raised huge concerns about safeguarding of children in custody, made 34 recommendations, found that around 1 in 10 members of staff DBS checks were not in date. We know, because we've had report after report, that there is huge scope for abuse where children find themselves in custody, often alone, often frightened, often exposed to severe violence, sometimes from each other, but also sometimes from staff. And it is a very frightening experience for a child to be sent to prison.
And it's certainly one thing that the report dwells on is the fact that children caught in the justice system are very likely to have experienced trauma, deprivation, learning difficulties. They may be neurodiverse. There's also
Absolutely.
I think minoritization is the word used in the report.
Well, first of all, we know that around 2/3 of all children in custody will have special educational needs, mental health issues. Lots of children have not even been diagnosed. I often will find that people who've been sentenced as children to prison are only diagnosed with mental disorders much later on. And sometimes those will be lifelong conditions like learning disability and autism that have been overlooked when they were children because they don't know how to articulate or explain. And sometimes it's really key to understanding the behavior that sometimes really awful behavior that they committed. And it's important context that was missing at the time.
Yeah, I'm very conscious the report contains a lot of sort of hard science, you might describe it, neuroscience and psychology. And policymakers would simply not have been privy to that information, even if it existed 60 years ago, not even 30 years ago, would they?
Yeah, but also, I think that's absolutely right. We've learned a huge amount about how the brain develops and the plasticity of children, their ability to learn from their mistakes, which probably we all recognize from our own experience of just growing up. But there's also some really obvious, basic logical facts that we've always known. So, for example, and this is something that my old boss used to say, Ed Fitzgerald, also Kirsty's colleague, said, look, if you had a 30-year-old man with the mental functioning of a 10-year-old child, you would say they're not fit to plead, right?
Yeah.
You would see that as a serious issue. So if you have a 10-year-old child with the functioning of a 10-year-old child, why is that okay?
Yeah, it's contradictory, isn't it? I think the history is interesting, isn't it? There's the Latin notion of doli or doli incapax, which is incapable of evil, which I think the new Labour government repealed in 1998, didn't it? Could you just tell us what that said and why?
I actually remember as a junior practitioner having cases where the prosecution had to show that the child knew that what they had done was seriously wrong, and there had to be a finding on that first of all. That was Dolly and Capax. So there was a presumption that children were not, when they committed some harm, were not capable of knowing that the harm they committed was seriously wrong. That was repealed, as you say, in 1998. So that then left us with a flat criminal responsibility age of 10 years old. And because of that repealing, without considering at that time increasing the age of 10, which should have been done, it should have been considered at that time, we've ended up as an outlier and having the lowest age in Europe.
But I assume neither of you would favour, well, why not just reintroduce that? Wouldn't that help solve the problem?
Well, we did discuss it actually in the working group on the report as to whether we'd recommend reintroducing it. And in some ways, although it was a good attempt to show that there was an understanding that children are different. However, we've got much more sophisticated neuroscience then, and it's not actually compatible with the neuroscience which is showing that children at that age do not know what is seriously wrong, what they're doing. And so it wouldn't actually fit with our modern scientific understanding of how a child thinks.
Do you agree, Laura?
Yes, I absolutely agree. And I think if we look back to when it was a thing, it obviously often didn't operate to actually prevent injustice and inappropriate prosecutions in the first place. And I think the other thing is sometimes it's a bit too simplistic. As Kirsty says, we know a lot more now about the nuances of how children develop and how the brain develops. But also, it may not even be the right question just to know the difference between right and wrong. Actually, many of us will say that much younger children do know that. It's about all the things that go with that. It's about your ability to exercise internal controls, to weigh up the pros and cons of doing the wrong thing, to stop yourself. And those are things we acquire. And actually, quite often, it's the things that we help our children to acquire, that children in loving and nurturing environments are given the skills to acquire. And that is not an even playing field either.
I think the history of Dolly and Capax is quite interesting as well. So, as I said, it's a rebuttable presumption, and it came from common law, and originally it applied to children aged from 7 to 13. And that has been the situation since. We could trace it back to writings of Hale in the 18th century, probably goes back much further, even 15th century. So the understanding in some ways was in some ways you could say it was slightly ahead of where we are now. Maybe we've gone backwards with how we're seeing children, because it was recognised then, that difference of how children act and how they think. And then what happened was that the minimum age of criminal responsibility was increased from 7 to 8 in 1933. And then it was, you've got the Dolly and Capax from 8 to 13. And then from 1963 until 1998, it then increased to 10. So you then had 10 to 13 on Dolly and Capax until, as we say, it was repealed in 1998. So there was that carve out that was there and was working reasonably well, although with modern eyes, still was producing unfairness, which is why we came down with saying actually a bright line of 14 is what's required on the minimum age.
Yes, you use the term bright line, don't you? Okay, let's look at the barriers to change. It's interesting. I in preparing for this, I looked for media articles opposing raising the minimum age. Very difficult to find any. It does seem to be a very popular cause, and frankly, as a layperson, I'm rather surprised that it's lingered this long, if that's the way to put it. But there will be critics. There will be critics who will say this is soft on crime. I did find one piece from the Telegraph which wasn't particularly hostile to the idea, but it did say raising the age will raise fears that young thugs will be allowed to run riot without risk of prosecution and deny justice to victims and victims' families in the most serious cases. So you will have to, if this does move towards being realised, you will have to address those concerns.
Yeah, I think the main point to address here is not being suggested that 13-year-olds are going to be roaming the streets with machetes.
Mm.
What the proposal is that there is another system and not the criminal justice system, which is shown to set the child on an even worse path. You've got 2/3 of children who, when they're released, they go on to commit more serious crimes. And then you have persistent offenders who are adults. They've all started off as children in the criminal justice system. So it's looking at an alternative, looking at civil processes. There already are some. They're not sufficient, they're not adequate, they're not adequately resourced, they're not adequately regulated. However, some of those diversion programs that we see in practice can be looked at, can be built out in how we treat children who are committing harm. And I think the other point to make is that if the minimum age of criminal responsibility is uh, increased, what you are potentially doing as a society is you are stopping that 10, 11, 12-year-old becoming that 14-year-old who commits serious crime. So that is the point, that by intervening in a different way earlier, you're preventing these serious crimes that we're seeing committed by children. Certainly from 14. There are some at 13, and I appreciate there will be, well, what about that 13-year-old? Would they now not be prosecuted?
Yeah.
But hopefully it will prevent reaching that stage.
So, senior practitioners, you talked about diversions. What specific diversions, so to speak, do you think are most to be recommended, most successful? And secondly, obviously, any politician will think, oh, well, that's going to be expensive, isn't it?
Well, actually, locking children up is very expensive.
Mm.
You know, the cost of keeping a child, even in a good, secure children's home, which is probably the best kind of custodial environment for a child, can be over £200,000 per child per
Wow.
year. So what we're doing at the moment is not a cheap option. The other thing, of course, is that's really important in terms of what Kirsty has just said is that unlike the adult criminal justice system, the youth justice system, the system for children has a purpose, right? The adult criminal justice system has none, which don't get me started on that. But the purpose of the youth justice system is to prevent crime. So it's to prevent offending, not to prevent reoffending, but to prevent offending. And what we know is that it is the system contact that is the single most thing that is likely to increase offending. And we know that from longitudinal studies. There's the Edinburgh study, which is cited throughout the report, where they looked at 4,000 children going through the system. So the other important thing we know is that children grow out of crime, right? We know that there is an age crime curve, which you see in every jurisdiction across the world, and it's the same, is that there is a curve up as you're in your adolescent years where you have a propensity towards committing crime, but you hit your late teens and then you start to stop. So in terms of the less serious offences, actually sometimes you don't always need to do something. We have a terrible urge in this country to sort of jump in and do things the whole time. And sometimes it's not necessary. When it comes to keeping the public safe, where it absolutely is necessary, and nobody for a second is suggesting that if somebody does something really harmful and there's a risk that they might do it again, that you just walk away, then there are all sorts of things that can and should be done and are done at the moment in respect of 9-year-olds or 10-year-olds that aren't prosecuted. And so those can include all sorts of things under the care system, but also support for families. They're listed in the report, so perhaps, Kirsty might want to say a bit more about it. But they can also be quite restrictive. They can involve, in necessary circumstances, a deprivation of liberty,
Yeah.
particularly where a child is at risk of harm or harming another, and that can be authorised if they're under 13 by the Secretary of State or the family courts. And so there are definitely better ways to keep everybody safe and actually prevent further harm.
So if this change did happen, Kirsty, would those diversions that have been discussed there, do you think they're fit for purpose as things are? Do improvements need to be made?
Well, they're certainly not fit for purpose. So there are deprivation of liberty orders that are available now, which can be used and imposed through the family court system. One of the challenges with those orders is that many placements are unregulated, and this means that children can be detained without a process and a procedure around them and safeguards around the length of that detention and that placement and how they're treated within it. So there's much that needs to be done. The family deprivation of liberty orders are absolutely not a direct alternative. However, there is a structure there that can be considered. What's important is really looking at the multi-agency intervention with children. And if a child is in the criminal justice system and in detention, any programs within that detention usually exclude the involvement of the family and parents, carers, whereas in the civil proceedings, putting it generally, they are set up to include carers, and they will have the advantage of keeping those anchors that a child has in society. Even though they might be strained, or rebuilding them. The difficulty and the failure of the criminal justice system is it removes those social anchors. And then you end up a child who is completely adrift and having been put within an environment of peers, which are not really your educational norm that you would be getting if you were in a different environment.
Okay, so if we move on to the political context, the report rejects exceptions. There could be a carve out, for example, for the most serious crimes committed by children under 14, but that's not something that you favour. You talk about this bright line.
The reason for rejecting a carve out, and there are countries which do have a carve out for example, homicide and murder and manslaughter cases, is that the bright line does bring a legal certainty to it. It's very clear to those enforcing the law as to whether they be acting lawfully and starting to bring the criminal justice process into effect. And carve-outs can bring a level of uncertainty within a process, in that quite often the full facts will only develop and emerge some way into the system. And by then, the harm would already been done. So if you find that you've brought a child into a system believing that they should be charged with murder, and then facts emerge that in fact they should not have been charged with murder, they would already undoubtedly have gone through a period of detention and been set on that criminal path that the report would be, and we would be seeking to avoid. So that's one of the reasons for having a bright line, of having certainty around it and avoiding actually, in part, bringing in that you're seeking to avoid, which is a criminalisation path.
I think it's important also to remember that we are the ones that are the outliers, right?
Yeah.
Scotland has increased its age of criminal responsibility, leapfrogging us, right? So it started at 8 and only a few years ago increased it to 12. And that's a bright line too. And it has not resulted in chaos or huge injustice or major problems. So again, have to stress, nobody is suggesting that people can commit harm with impunity and that nothing will happen and there won't be measures to keep people safe. But equally, we can see the world over examples of almost every other country, certainly in Western Europe, having much higher ages of criminal responsibility, almost entirely without carve-outs, where it's not an issue. It hasn't caused social
So the
disarray
proof
or
is
major
there
problem.
if the politicians
The
choose to
evidence
look
is
for it.
there.
The evidence is there. Yeah. So the government has already said that the report will be considered as part of youth justice reforms. Realistically, what do you assess to be your chances of success? Or I guess we might have a new Lord Chancellor soon. Who knows? But
Actually, my impression has been that this Lord Chancellor, David Lammy, has been very supportive of considering reforms of children in the justice system. And so I hope, if he doesn't remain in position, that whoever his successor is carries on with that approach, because there's absolutely no doubt that our system is not functioning in relation either to the children or to the public. And therefore, it is long overdue to have reform. What is interesting is that in 1969, it was in fact on the statute book that the minimum age of criminal responsibility be increased to 14, and there was a carve-out for homicide. It was never brought into force, and it was repealed in 1991. But our parliamentarians were mature enough then to recognise that 10 was too young and something needed to be done. And it was unfortunate that there wasn't then the political will to fully bring it into effect. What's going to happen next? Well, Professor David Ormerod has been appointed to do his own review on youth justice. Now, he has a terms of reference structure that actually excludes, or certainly doesn't include, looking at the minimum age of criminal responsibility. So what we're urging is that the government, as well as saying in the white paper that, of course, our report will be considered, that it also should expand Professor David Ormerod's terms of reference so that he can bring in his expert academic analysis and looking at the system as a whole, because everything flows from what happens with children who commit harm and what path they're put on. And so it doesn't seem logical for him not to look at the minimum age of criminal responsibility at the same time as everything else he'll be considering.
Okay. How hopeful are you, Laura?
I don't think I could put a bet on it. Let's say that. It's just really important to have these grown-up conversations. It's good that the government has said that they will consider it. But also, we've seen a huge change in practice. So when I first started working with young people and children in prison, which is almost 20 years ago now, there were 3,000 children in prison at any one time. There were 10,000 children going through the gates, okay? The number of children in prison today is just over 400. So that is an absolutely enormous decrease. And that has happened through change in practice. And that is really, really welcome. So even if we don't see a change in the law that's been recommended by the Bar Council, I think having these conversations, understanding the reality, the granular reality of children's lives, what needs to be done to keep everybody safe, thinking about it actually from a safeguarding perspective for everybody, the children, victims, potential victims, the public and their families. All these conversations are really important in fostering change.
I do hope there is a change, though, just picking up on what Laura said, because globally we are looked at as like, what are we doing? And there is a real point as to how we are as a society, how we treat children does reflect on us as a society. They're some of the most vulnerable people in our society. And for us still to be such an outlier is Dickensian in how we approach children. And that is what needs to change. There's no reason why it shouldn't change. And we need to do it. We need to do it on the statute book. And that then sends a signal out to everyone that we treat our children appropriately, we safeguard them appropriately, and we also recognise their vulnerabilities and seek to put them on a path which is one where they can have fulfilled lives as adults. And we can do that. But we can't do that through the criminal justice system, or it's much, much less likely if we keep putting our children through these court processes.
You've just reminded me of a time I went to Belarus to talk to prosecutors and judges where they were thinking about increasing the age of criminal responsibility. And they asked me all about our system. And afterwards they said, oh dear, I don't think we want to do that and follow that example.
And this is Belarus.
Yeah.
Okay.
So you're absolutely right that we are outliers.
Okay, thank you very much. We can probably conclude then. I'll just ask one final question. What would be the single statistic or the single trend that you would point to in your report as compelling evidence of the need for reform?
I would ask that there's an approach to this which is a wider approach outside the criminal justice system, and look at how a higher minimum age of criminal responsibility allows greater scope for diversion and rehabilitation of the child who has committed some harm. And the effect of that being that it will better serve not only the younger child becoming the older child who commits a serious crime, but also better serve the public. better serve the public, not only at that time, but prevent members of the public becoming victims in the future.
Thank you. Laura, this is in the public's interest.
I think that's a very important point. I also think, just thinking about it from a completely different perspective for a moment, the law is very quick to tell children that they cannot engage in sexual activity until they're 16 and vote until they're 16. So how is it logical to say that a child knows enough to offend at the age of 10? And one of the interesting things is not only are we an outlier in terms of having the youngest age of criminal responsibility in all of Western Europe, and actually globally, really, out of most countries, we have the biggest gap between the age of criminal responsibility and the age of consent that I'm aware of, certainly.
An excellent note on which to end. It only remains for me to thank both of my guests, Dr. Laura Janes, Kirsty Brimelow, KC, for giving their very precious time today. Thank you so much.
Thank you.
Thank you very much.
This has been the Law Society Gazette podcast. We hope you enjoyed it. Do join us next time. Thank you.